Greetings, my fellow Americans. Do you live in a tyranny? Let's find out today. Because today we're going to be talking about the difference between a grand jury and information. Now, most of you, I imagine, hearing this or reading this, if you're reading any summary of this, or if you've read my blog, you know what a grand jury is. A grand jury is between 12 and 23 people appointed for the purpose of deciding whether or not a criminal conduct has occurred, i.e., they're the first line of defense against a criminal prosecution. If somebody wants to throw a charge at you, this grand jury will examine it, make a determination whether or not a felony has been committed, and then if they don't find any evidence of it, there's no charge. Prosecution can't proceed. The Fifth Amendment specifically says no person shall be held to answer for a capital or otherwise infamous crime unless on the presentment of an indictment of a grand jury. U.S. Constitutional Foundation there, ladies and gentlemen. U.S. Constitutional Foundation. Montana doesn't feel bound by it. When you have a tyranny or you have a tyrant here or there, you always hear about people being picked up off the street and thrown in jail. They control the courts, the mockery of courts. They control the mockery of legislation, of government, whatever. They are thrown in jail. Just because they're political dissidents, the government doesn't like them, they cross the street on Tuesday instead of Wednesday. It doesn't matter. Tyrannies can throw you in jail for anything they want to, and guess what? That's what happens in Montana. It's what's happened to me, it's what's happened to every single person who's been prosecuted in this state for the last 100 years. Don't believe me? Let's review the facts. As I said, the Fifth Amendment of the United States Constitution provides that no person shall be held to answer for a capital or otherwise infamous crime, otherwise known as a felony, unless they're presented with an indictment by a grand jury. Now, this should be very simple. Everybody has a grand jury, right? You see it on the TV shows, you see it on the documentaries. They go through the grand jury returns an indictment, this person gets arrested. Not in Montana. In Montana, the actual law reads completely different. Whereas a grand jury is designed to protect against malicious prosecutions, Montana has specifically written in their law book that they can do whatever they want. Literally, if the person in power, the prosecutor and the judge, are in collaboration and they want someone arrested for something. It doesn't have to be true. Just they want them arrested off the street, no review of evidence. Again, let's look at the facts. Montana Civil Code annotated 46-11-101. Look it up. The methods of commencing a prosecution in Montana. There's 4 ways. You can file a complaint. Now keep in mind, complaint does not require any preliminary review. Just file a complaint. The prosecutor decides he wants to prosecute someone. All they technically have to do is file a complaint. I.e., I'm going to file something with the court and allege a crime has been committed. The second method is information following a preliminary examination or waiver of a preliminary examination. This is important. 3, an information after leave of court has been granted. Or 4, an indictment upon a finding of a grand jury. Now, it doesn't say, this is not a preliminary list of priorities. So the fact that the indictment by grand jury is the last does not any means mean is the last course. Technically, according to the U.S. Constitution, it's the only method by which a felony can be brought. The only method by which a felony can be brought. Montana says there's 4 ways to bring it. Now, the complaint method I've not seen used, except in like misdemeanors. So it's not really an issue of concern here. But what the other 3 are. Now, it's not an and. It's not a, this method shall be used first. If that method's not available, this method shall be used. If that's not available, this method shall be used. It is literally an or option. It's optional. Prosecutors can, 1, pursue a charge based upon an information following a preliminary examination. 2, an information after leave of court, i.e., no preliminary examination. They just file something with the court, ask for court permission, the court grants it, they file the information. And 4, the indictment by a grand jury. Now, of these 3, if you're a prosecutor and you want the most expedient way to prosecute people without any oversight, without any obstruction, make sure every single one of them actually goes through, Why would you go through the process of a grand jury or requiring an examination or waiver of a preliminary examination? Why not just jump straight to the ball? I'm going to file a request with the judge, and the judge will sign off on it, and I'll be able to issue a arrest warrant and put the person in jail. When you have an option that requires absolutely no oversight and no criteria, it's left to the ethical boundaries of the individual holding the office as to what method they pursue. And the path of least resistance is always the one by human nature we are going to choose. A prosecutor, whether they're corrupt or not corrupt, wants the single most expedient method to pursue prosecutions. Because the more prosecutions they can pursue, the more they can get people in jail, the more the prison for profit system is fed, etc., etc., etc. The ball rolls and rolls and rolls. So, guess what? Every single prosecution I have ever reviewed in the last 15 plus years, well, 18 years, I've been doing a whole heck of a lot of review of other people's cases. I've never seen anything but the information system used. The third criteria, the information as granted by a judge. Not a grand jury, no preliminary review, no preliminary examination, no nothing. A request to the judge grants it, person's in jail. Anyone remember tyrannies here? When you don't want someone on the street, you just say, hey, I'm going to order an arrest warrant to be issued, have them thrown in jail, and be held until I decide otherwise. Congratulations. Welcome to Montana. That's the law, folks. It's right there. And if you don't believe this is how it works, they wrote an entire law just to define that little section. It's called MCA Section 46.11.201. And that law reads that all the prosecutor has to do is file a leave to file information. In other words, may I please file this information, Your Honor? And it says the prosecutor may apply directly to the district court for permission to file information against a named defendant. That's it. They get to go directly to the judge. No preliminary examination, no grand jury, no opportunity to challenge whether the actual charge is even real. I think Jim Bob, I don't like Jim Bob. I want him off the street. I'm going to say he smashed his daughter's nose. Jim Bob may not even have a daughter because the judge never reviewed the information, evidence, anything. Jim Bob doesn't have to have a daughter. Jim Bob doesn't have to have committed offense against anybody. All the prosecutor has to do is say that's what Jim Bob is being arrested for, and Jim Bob is being arrested, and he's held indefinitely. Now, this is a really interesting point because the section clause of this law says an application must be by affidavit supported by evidence that the judge or chief justice may require. But the judges and chief justices don't require anything. They consider the affidavit to be evidence alone. Now, keep in mind, anyone who knows the basics of law should see the flaw in this, because a prosecutor cannot testify to hearsay. Prosecutors are not supposed to be testifying to begin with. They are the prosecutors. They can't offer evidence in the case. They present evidence in the case. They're not supposed to be testifying to the court. And they certainly can't testify to hearsay, because anything the prosecutor does outside personal knowledge or writes about is hearsay, and it's inadmissible. A prosecutor can't say Jim Bob hit his daughter because the prosecutor didn't witness Jim Bob hitting his daughter. It's hearsay. It's inadmissible. Not in Montana. Number 3 says when a leave to file an information has been granted, a warrant or summons may issue for the defendant's arrest or appearance. That's it, ladies and gentlemen. There you are. 1, 2, 3. Bam. You're arrested. Not on a grand jury, not on a preliminary review, no preliminary examination of any kind. The prosecutor writes an affidavit, the judge accepts it, signs off on it, issues a warrant. On the warrant, you go to jail. I mean, what else can I say? How do you not see that as a tyrannical system? How do you not see that as a government overreach? The founders of our country created the grand jury system to prevent this exact thing, to prevent this exact kind of manipulation of the law. Because you have a prosecutor who can pursue any personal grudge, grievance, political ambition, whatever, and throw any number of people in jail just to fill the jail beds, just to show that they're doing a good job, because they're arresting criminals, and that's it. That's it. That's all. We're in jail. Now, the really important thing here is that this particular issue, the reason why they're being allowed to do this, is because the U.S. Supreme Court made a horrendously bad decision back, so long ago. Okay, um, and the case in specific is is known as Hurtado versus California, and you want reference to it is 110 U.S. 516 1884. Okay, it was the challenge in the court before the court was whether the 14th Amendment's due process clause prevented the use of an information to bring a prosecution. Okay? That was the case. A state decided, we're going to bring a prosecution, we're going to use information instead of grand jury, and they were challenged on it. Went before the U.S. Supreme Court. The U.S. Supreme Court said, we are unable to say that the substitution for a presentment or indictment by a grand jury of the proceeding by information, after examination and commitment by a magistrate, certifying to the probable guilt of the defendant, with the right on his part to the aid of counsel and to the cross-examination of the witnesses produced for the prosecution, is not due process of law. Horrifically bad decision. Horrifically bad decision. Because what they did was they completely excluded the applicable aspect of the 14th Amendment. The actual issue, because the 14th Amendment actually says this, is no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. The Fifth Amendment is a privilege and immunity of citizens of the United States. It specifically requires that any felony, infamous crime, must be made on the presentation and indictment of a grand jury. So an information system, a complaint, anything should not allow it. But because that particular case, they were only examining whether that aspect was a due process violation and not whether it actually violated the 14th Amendment as a whole. It was touted as a championship for states to bypass grand juries. But here's the important part. Even that case said that it required that there be a preliminary challenge of evidence, the aid of counsel will be provided, and an opportunity to cross-examine witnesses, all before the information was granted. So there was still a preliminary examination under the United States Supreme Court's judgment. The expectation was that there would be a preliminary examination of evidence to determine whether or not a crime had even been committed. The defendant would have an opportunity to challenge the evidence, to cross-examine the witnesses, and determine and have a court determine, based upon actual consideration of the evidence, whether a crime had been committed, and then instead of a grand jury indictment, proceed to information and file an information. Remember, that is the second actual category under Montana law, after complaint, is this procedure as identified by the United States Supreme Court. But Montana said, oh, that's just too much. Let's add another area where we don't even have to do any of that. Let's just say the prosecutor can go directly to the judge and bypass all of this, all the civil liberty protections, all the immunities, all of the challenges that a citizen has a right to normally do, and we'll just throw them in jail. Welcome to Montana. That's the way it's written. And you ask how this system exists, how it empowers itself. Welcome to the Great Montana Conspiracy. Because this wasn't one person passing this law. A conspiracy, by definition, is multiple people getting together to accomplish a criminal act. This is a constitutional travesty. Because there's absolutely no foundation for it under constitutional law. Now, interestingly enough, the U.S. Supreme Court came back in 1925 and actually wiped out the ruling in Hurtado. There's a case called Gitlow versus New York, and its actual citation is 268 U.S. 652, and again, it's in 1925. Just for frame of reference, the 14th Amendment was actually passed in 1789. Just for clarification, so Hurtado was a ruling in 1884, almost a full century after the 14th Amendment was passed. Okay, then Gitlow versus New York came out in 1925. So we have this whole issue of whether or not these issues actually are relevant. Well, they're a sequential timeline. But in Gitlow versus New York, the U.S. Supreme Court ruled properly and adjudicatedly that states are bound collectively to not violate citizens' rights guaranteed under the Bill of Rights, the first 10 amendments of the Constitution, by virtue of the Due Process Clause of the 14th Amendment. So in 1925, they said no rights, that would include grand jury, may be taken away by the states. The states cannot take away the rights guaranteed by the federal Constitution, by the Bill of Rights. And the 14th Amendment's Due Process Clause prevented that. The problem is that because it did not specifically address Hurtado, it did not specifically say, and discuss Hurtado or its implications or anything else, everyone considers that Gitlow versus New York does not actually overturn Hurtado. It doesn't examine Hurtado's conclusion and then say its findings were incorrect. Therefore, it does not specifically and directly overturn Hurtado, although it does, by its very nature and its all-encompassing aspect, trump it. It says this is a ruling that is broad over all Bill of Rights issues. It doesn't say all Bill of Rights issues except as those are addressed in Hurtado. It just says that all rights under the Bill of Rights, under the first 10 amendments, are secured and guaranteed, and the states cannot take them away. Montana's ignored this, and they said, we're going to rely on Hurtado, just use information, and that's how we're going to do it. And they didn't care that the method they created is technically unconstitutional, even under Hurtado. But that's the foundation. That's what they rely on. They rely upon the existence of a U.S. Supreme Court case that says that an information system is justified to bypass a grand jury. Doesn't matter that it's been trumped since by greater legislation, and the United States Supreme Court has not since reviewed the case. No case that I've ever seen has ever been brought to challenge Hurtado. Therefore, because Hurtado has never been challenged or specifically overruled, they're relying on that as justification to proceed with a clearly unconstitutional aspect. And even, again, under the ruling in Hurtado, even Montana's system is broken. It's unconstitutional because it doesn't allow for a preliminary examination of evidence. Now, a very important factor here, even after the information is granted, even after the arrest, Montana is not required to give a preliminary examination of evidence to defendants. So even if there was a hiccup in saying, okay, we're going to grant the information, then immediately grant a preliminary examination of evidence to satisfy the constitutional boundaries that we're bound by, maybe there might be some argument. But Montana doesn't even have a preliminary examination guarantee. I was never given a preliminary examination. No one's given a preliminary examination. You get arrested, you get thrown in jail under the information. There's no requirement that thereafter a preliminary examination be held. So there's never a point at which the evidence is examined until the person reaches trial. Now remember, as I've said in the previous videos, the idea here is that nothing we say or do makes any sense if the very foundations of the law are ignored. We go through and we put people in Montana, in Flathead County specifically, put people in jail, put them under incredibly high bails, ignoring the 8th Amendment's specific ruling against excessive bail. Again, Montana ignores the U.S. Constitution, throws those to the wind because they want to. Hold them, convince them to sign waivers of speedy trial rights, hold them until they're willing to either break or can take them to trial, and of course they control what evidence is brought in, what evidence is not, what the jury sees, what they don't see. So they're really, puppet masters of the whole thing. 99% of the time, people actually succumb to the plea bargain. They say, I'm tired, I'm worn, I can't do this anymore, I'm losing my job, I'm losing my family, I'm losing my income, I'm losing my property. Everything I have on the outside is going away because I'm here. I have to do something to get out. They can't afford these excessively high bails. They can't get before a trial and prove their innocence. They have no opportunity to challenge the evidence brought against them, and they are held indefinitely. Remember, once again, as I said at the beginning of this video, why is this not a tyranny? How is this a democracy or even a republic if you want to use the actual definition of what our country is. This is not the people. This is a tyranny. This is a despotic tyranny that is coming out and erasing our rights and taking people off the street without due process, without probable cause, just because a prosecutor wants you off the street and the judge goes along with whatever the prosecutor wants. We sit here and we try to talk about equality and fairness in this day of Black Lives Matter. But you can't have any rights for any citizen, black, Latino, white, whatever. You can't have any rights if you don't have the basic principles of constitutional law. And if Montana can ignore it, anyone can ignore it. And Montana just does it. Over 100 years of prosecutions in this state have been based upon this foundation. Why? Because in 1889, the U.S. Supreme Court made a bad decision and ruled a wrong aspect of the 14th Amendment. They corrected it in 1925, but nobody listens to that because it didn't specifically overrule the 1884 case. And Montana said, I see an opportunity, or we see an opportunity, as the case may be. And because no one's ever challenged it, or I have, but everyone ignores me, nobody in a proper sense has ever had this brought before the Supreme Court because the Supreme Court gets to decide their cases. They aren't mandatorily required to overlook any case. We don't have to listen to cases that we don't want to, and we're only going to listen to the ones that actually seem to be issues that we care about. So there you go. Montana gets to arrest people, throw people in jail, hold them indefinitely because of this system. Now, interestingly enough, in 1884, when this case was originally brought before the United States Supreme Court, the idea was not lost on everyone. In that case, in the 1884 Hurtado case, Justice Harlan wrote a scathing dissent. And I'm going to read that. It's a little bit lengthy, but I think it's really important to understand. He starts off with, what all of them seem to have missed, including the litigants, is that the issue is not just whether the grand jury indictment is part of due process, guaranteed by the 5th and 14th Amendment. The 14th also provides, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. This language, going back to his own quote, this language was made the opening statements of the 14th for a reason. They were not without force and effect. They were not intended by the framers of the 14th to extend the jurisdiction and protections of the federal courts to all rights recognized by the constitutions. They were intended, they were not intended. They were intended by the framers of the 14th to extend the jurisdiction and protection of federal courts to all rights recognized by the Constitution and Bill of Rights against actions by state government. First, any law includes the state constitution, which is the supreme law subject to the U.S. Constitution. Second, immunities includes all those rights recognized and protected by the Constitution and Bill of Rights, including those of the 9th and 10th Amendments. The framers of the 14th used immunities because the rights recognized and protected by the Constitution and Bill of Rights are rights against action by government, which are immunities, as distinct from the non-vested rights of business. If there is any doubt as to what the framers of the 14th meant by their words, here are some of their words taken from debates in Congress and the press during the drafting and ratification debates on the amendment. And it says, quote, see, quote, intent of the 14th Amendment was to protect all rights, end quote, by John Rowland. That's actually cited in his dissent. And now this comes from that book, or that article. From the legislative history of the 14th, it should be clear that all the rights recognized by the U.S. Constitution are not only rights against state action, but that the 14th Amendment authorizes Congress to legislate protection of such rights against state action and grants jurisdiction of federal judiciary over cases between citizens and their states involving them. Among those rights are the right to keep and bear arms and the right to a grand jury indictment. While the Supreme Court might reasonably have confirmed this in any given case by only declaring such rights as are minimally needed to render a decision, it is important that they not fail to do so for all the rights that are issues before the court, and the precedent of the Hurtado case needs to be reversed. Again, from the quote of John Rowland. Obviously, this was not attached to the original congressional debate, because obviously Hurtado happened after the congressional debate. So we have what we have. But the point is the issue has been made, and it has been dissented. The issue here is not whether or not an indictment is a fair system. The way Montana applies it most certainly is not. It is purely state action. The Constitution, the Bill of Rights, were specifically designed to prevent government misconduct. It was specifically the freedom of press, the freedom of speech, the right to bear arms, the right to a grand jury, the right to a speedy trial. All of these issues were issues to prevent this very thing from happening. And Montana flaunts its nose at it because no one in the federal system will do anything about it. And here we are. This is why the Great Montana Conspiracy exists. If my case had been examined by a grand jury, there is absolutely no way it would ever have gone past a grand jury. By the time I was prosecuted, there were 6 different versions of the allegation against me by the same person. 6 different versions. One person, allegedly a 10 to 15 second act with details that changed 6 times. There's no way a grand jury could look at that information and say, a crime was committed here. Because of a very simple principle of law, and I've mentioned it before. When 2 disparate statements are made, it is not necessary to tell which is true, only that both cannot be true. Preliminary definition of perjury. With that principle of law, 6 contradictory statements presented as evidence would never have seen me put in jail. Because a grand jury couldn't look at 6 statements and figure out which one was true, because there's no way to prove any of them are true if all 6 are different. And there you go. The information versus the grand jury system. Montana should have, it actually has the language in its laws to allow for it, but no requirement or mandatory element that it be used. It is literally one of 4 choices being brought in order to bring a prosecution. And the method of least resistance is one in which the prosecutor simply writes a statement and says, hey, Jim Bob did something bad. We think he should go to jail. And the judge just signs a signature. How is that fair? How is that just? As always, ladies and gentlemen, I hope you took something out of this that is worthwhile, that is actually going to give you something to recognize how corrupt this system is, where this problem exists, and what needs to be done. And it can't be done by the people who are in power, because the people who are in power are the ones who are doing this. And they're not ignorant people. They're not. These people actually know what they are doing. They recognize the criminal misconduct, and they throw people like me into jail to silence the objectors because the law allows them to do so without any kind of oversight. There's no checks and balances here. There's nothing to stop them. I speak out against them. I say they're criminals. Let's make up a crime and throw them in jail. That's all that's necessary. It's why I'm a political prisoner since 2004. Because I spoke out against them. I tried to make people make statements against corrupt police officers who are making sexual and physical assaults on teenagers. Oh, Mr. Glick is out here trying to bring charges and public scrutiny upon our misconduct. Let's throw him in jail. Not did he commit a crime. Not did he do something wrong. Does he deserve to be in prison? This man is wanting to expose our crimes, so let's throw him in jail. That, ladies and gentlemen, is the core definition of a tyranny. It is a Gestapo-style government that the Nazi government ran. It is the one that England and France both did against their colonies, throwing people in jail indiscriminately just because the magistrate of the colony allowed it. And this is what the framers of the Constitution wanted to protect against. They have to roll in their graves if they are even aware of this. The problem is it's buried. Nobody sees it. Conspiracies exist because they are buried most often because more people in positions of power and authority get to cover it up and say it doesn't exist, it's not a problem, and people like me are the sole voice out here. I'm backing up everything I'm saying with the law, ladies and gentlemen. I gave you the Montana laws. I gave you the U.S. Supreme Court cases. In my book, I scan literal documents. I don't make my claims and just say, this is what's happening, this is what you need to be aware of, and you won't find it because they've struck it from the record. I'm not a conspiracy theorist. I am a conspiracy realist. This really exists. And if you can't see that, then you're just waiting for it to happen to you. Because sooner or later, either you or someone you know or care about will be subject to this very problem if you live in Montana. Someone you love and care about is going to go for jail for something they didn't do because someone has a grudge against them or someone doesn't even care to look into it. So what are we going to do about it? I'd love to hear your feedback. As always, as I say, I hate this part of the podcast because I hate doing it, but I'm running on an iPhone 8 trying to spread information. I want to be able to interview people. I want to be able to split screens and go away and say, okay, I'm talking about this. Here it is. Put it in front of you so you can see it in black and white for yourself. At this point in time, I have to send you off outwards from this video to actually look for this information. I'll cite it. I'll tell you where to find it. But you have to go looking for it, and it's not here right on your screen. And that I apologize for. I'm using an iPhone 8. I don't have a sophisticated studio. I don't have a sophisticated, editing software. I have whatever I can get off the internet. I have whatever I can use at my disposal. And it takes money to run a podcast effectively. So if you believe in this cause, if you believe in the information I'm spreading around, if you believe in what I'm trying to champion here, support us. If you just believe that there's even a slim chance that anything I say is true, you should be scared. You should be scared because this can take away anything. This right here, what I said today, can literally throw you in jail on a whim and hold you there until you break. And if you don't think you'll break, no one thinks they'll break until they're inside. Go spend 12 months in a concrete walled hole. Go ahead. Then decide. But again, back to the original topic. Of course, if you want to support us, you can send material donations. You can send monetary donations. The methods and resources are in the information attached to this video. If for some reason you're watching this video and it doesn't have any of that information attached, by all means go to monspiracy.podbean.com, the original broadcast point of this podcast. Also, I strongly recommend you visit my YouTube channel. Like, subscribe, because that is how I will get distribution and awareness of this podcast. And if you are detained or if you are under any supervision, I can't speak with you. It's not my choice. It's one of my conditions. If I speak to you, if I have any communication directly with you, I go to jail for 15 years. I go to prison for 15 years because it's a violation of the conditions of my release. And I say release loosely because I'm still under detention and custody of the state of Montana. I'm just not in a prison cell. Still a prisoner, just not in a prison cell. And if they want to put me back in a prison cell, they've tried twice. They will try again here in the next couple of years. I can almost guarantee it because they don't want me out here speaking and they want to be able to have these restrictions over me. In the meantime, please contact my producer. That's Bill Russell, and his information is also in the information attached to this. Again, if you're watching this video without attached, please visit the original source or my YouTube channel so that you can actually get a chance to contact us and give us the information you have. And especially if you have testimonials, we want to hear from you. We want to be able to put your information on here. In my current context, it'll involve me largely reading your statement, but any information is better than no information. So I'm going to wrap this up. I thank you for your time, and as always, if at all possible, please be free.